Leslie, since you presented first, would you care to give us some key takeaways?
Sure. So I think the key points from my part of the presentation is that courts find claims for diagnostic tests are not patent eligible because they claim a law of nature or natural phenomenon without an inventive concept. There is a concern as to whether this inventive concept of step 2 of the Mayo-Alice test subsumes the novelty obviousness analysis of sections 102 and 103 of the Patent Act, and whether that presents a problem in the overall analysis of the validity of the patent. Also, clever claim drafting could convert a claim for a diagnostic method into a claim for a specific treatment as long as the method of treatment is very specific and new, and the analysis is of the claim as a whole, not separating out the judicial exception from the rest of the claim. Of course, that won't always be possible. I don't think it would have been possible in the claims in Athena. And the last point is that since the court has denied cert for Athena and other Section 101 cases, it's apparent that the Supreme Court will not be revising any jurisprudence on patent eligibility under Section 101, leaving Congress to take this issue up. And that brings us to where Brendan started his talk.
And thank you so much, Leslie, for taking the time. Brendan, we also want to give you the chance to sort of sum up with your key takeaways.
Yeah, and I think, you know, sort of the narrative that I was trying to provide here is that this is really, it's a story of the three branches of the government, in that Congress kind of started this all with enacting 35 USC 101, but over the past number of years, it's been the courts that have been really deciding what 35 USC 101 means and how it should be applied. And it's only been in the last 8 years that we've really seen some dramatic interpretations of what that means. And it's also been continually evolving, and it's left a lot of uncertainty in the field. And one of the areas you can see that uncertainty is with the PTO. So the PTO has been somewhat reactionary in that they're trying to keep their eyes on a moving target here, because the case law is evolving. And, you know, as Leslie mentioned, it doesn't look like we're going to get even that much more resolution from the court system or the Supreme Court, because they're not picking these cases up to give us some more clarity. So what I think is what we really need, and hopefully we're headed in that direction, is to try to get some clarity from Congress by enacting putting forth an amendment that will help spell out what the boundaries are of 101 and the interplay between the other sections of the statute.